Welcome to the Data Stream, the podcast that dives deep into the fast-moving currents of data, technology, and the law. BakerHostetler's Digital Assets and Data Management Practice Group brings you this series, hosted by partners David Sherman and Nichole Sterling, to explore how companies navigate the complex and often intertwined lifecycle of data, from privacy and cybersecurity to advertising, AI, and other emerging technologies. I'm Charlie May, and you are listening to Baker Hosts. On today's episode, David and Nichole talk with Janine Anthony Bowen, of counsel in BakerHostetler's Privacy Governance and Technology Transactions team, and leader of the firm's Student Athlete and NIL practice team. An engineer, lawyer, and sports enthusiast, Janine brings a uniquely interdisciplinary perspective to her practice.
Janine, thank you so much for joining us today. For people listening who may not know you as well as we do, how do you usually explain the through line of your career from your engineering to technology transactions to sports and NIL work?
So it's a great question, David, and I actually had to think fairly deeply about it. So at my core, I'm a problem solver, and I'm also a simplifier, and I really love to learn and master new things. And the final point I'll add is I like to leave things better than I found them. So if we take those 4 bullets and kind of track through, industrial engineers are by definition solving system level problems. And so that has resonated and just flown through my entire career. And then when I moved into the practice of law with the tech trans practice, actually while I was still in law school, I started working with a software contracts group at IBM. And I was on the business side, and those were software vendor contracts. And in that role, I was solving vendors' problems because there were opportunities for them to have expanded relationships, business opportunities, if we could figure out how to get them into relationship with IBM so IBM could commercialize their technology. So again, problem solving going through that. And then as we moved into the tech trans space, that became more of an opportunity for problem solving and creating opportunities for clients. And this is where the simplification gets in, because sometimes these deals get very complicated, but the ability to simplify and create efficiencies has really added value. And, part of problem solving and simplifying is getting things done. And so over the entire course of my career, which has been about 28 years in this point, there's only been one deal that I have not closed. And I'm still bitter about that deal because they just would not concede a point that had to be conceded. And so I take pride in this notion of getting things done the most efficient way possible. That's come into play with my board work, where I solve a lot of governance problems in my nonprofit board work. And then as we have moved into sports and NIL, I have begun to identify system level problems in the sports context and figure out what some solutions might be to them. So through everything, problem solving is the through line that connects all those things together. And because each of these things are different, this idea of learning and mastering new things, I never get bored with the nature of my practice because there's always something new to learn. And I really do try to leave things and people better than I found them. And each of these ways that I've lived through my career has given me the opportunity to do that.
So all of these pieces, as we sort of take them together, really kind of go into how I've heard you describe your practice before to clients as sort of at this intersection of technology, data, and value creation. Mm-hmm. What does that mean? Like day to day when you're working for a client, how does that translate for them?
Yeah. So the goals depend on whether I'm, kind of customer side or vendor side with respect to the representation. But on the customer side, where I spend most of my time, technology is a business accelerator. And our clients, our customers of technology want to maximize their opportunity to accelerate business results. And so from a contractual perspective, I have to protect what's important contractually, but I have to recognize that value does not equal perfection. Value equals good enough from a contractual perspective. And so when I talk about this notion of value creation, it is how do we put you in a position to be more successful as a business without creating barriers to you doing that. Now, that also means that it is very helpful to understand technology and is very helpful to understand the role of data in value creation, because certainly now, beyond the technology, there is real value in doing things that with the data that is collected, either delivering value to a current client set or delivering value to a new client set. So understanding the role of data capture and data massage to create value. And then understanding data from the risk and reward perspective, which gets into compliance and some other things. So that's where that intersection of those things meet. And I work really closely with clients to make sure that we're aligned on what they're trying to achieve and that we've been thoughtful about the opportunities that might not currently be in scope, but we certainly want to preserve the right to pursue later on.
You're just helping me prove the point that everything is about data these days.
Absolutely right.
So taking that all together, when you walk into something, you walk into a deal, super complex, really complex technology deal, how do you get your arms around it? Because we know it's not all just about the contract, but you have to understand some of the systems as well. Where do you start?
Yeah, as a matter of fact, the contract is the last piece when you're trying to get yourself around a deal. So it's very important to learn the technology, or at least learn what the technology does. And so how do you do that? You can, review the website to see how the client talks about what the technology does. It's actually interesting to maybe skim the contract to see if there's a description of services that might describe what it does. I am very comfortable asking for a demo, asking for wireframes, asking for any descriptions of services that are made kind of from a marketing perspective to understand what's going on. But also I spend a lot of time asking the client to explain the product and then asking questions as they're talking about that, right? So client will begin to explain what it does. And as ideas come into my head, it's important for me to get real-time responses to make sure that I have clarity. Okay. And it's always important to know the problem that the technology is supposed to be solving. We need to know who the customers are, what the revenue model is. We need to know if we're dealing with software, whether we're dealing with cloud, whether we're dealing with mobile apps. Is it hardware? Is it data? Is it services? Is it some combination of all of those things? And so really digging into and being very comfortable asking questions about the technology really puts me in a better position to understand what matters in the contract. And that will begin to guide the contract strategy and the negotiation strategy.
So a slight pivot on that concept, right, of just given your background from both the business side and the legal side, what's one habit or way of thinking from the business world that you brought with you into your legal practice? Maybe that contributes to part of your last answer, but I'm curious.
Yeah, that's a good follow-up. So I think there are two habits, actually. One is an engineering habit, okay? It's important for engineers to make things work, but things do not have to be perfect. And so earlier I alluded to value does not necessarily equal perfection, because what a client wants is a workable solution, and perfection is not the goal from a commercial transaction or technology transactions perspective. So that first point is knowing that it has to work, but it doesn't have to be perfect. The second thing is you have to have some understanding of how all the pieces work together. And so the context of the technology or the context of the deal or the universe in which the client sits is relevant to determining how you want to structure the negotiation and getting the deal done. So first, understanding perfection is not the goal. Workability is the goal. And second, understanding that you have to have the context of how all the pieces fit together in order to make the right decisions. And those are the two things that I brought from other aspects of life and profession into my practice.
So one of the things that a lot of our associates have told me in the past is that you're really good at helping clients make decisions without getting lost in a lot of technical detail, that you're able to sort of cut through that and find like what are the actual key decision points. How do you personally translate technical complexity into plain English business choices that a client can actually act on?
Yeah. So, I was reflecting back on this question, and I recall several years ago, I did one of many personality profiles. I'm sure you've done lots of them as well over your career. And one of them indicated that I was not quick to respond, that I like to step back and wait before I jumped into a conversation. And for several years, that rubbed me the wrong way because it made me seem like I wasn't the kind of go-getter in a discussion. But what I recognized was that over time, what that meant was that I listened to the explanation of what the client wanted. And I asked questions along the way. And after I did those two things, I have learned to say it back to them in plain English terms. So if the client is describing technology or the client is describing a business problem or whatever the client's describing, I want to listen for their explanation, ask them to give it to me and listen to it, interrogate it, and then say it back. That frees the client to do a couple things. That frees them to correct me if I'm wrong, which I need, to add color or context if that's valuable. And so once they do that, then I say it back again. Okay. And at that point, I have simplified it in a way that I can hold it in my head. So I don't lose the complexity in my head, but the conversation loses its complexity. And we can talk about the issues that really matter from a problem-solving perspective. So those are the things that I have done, the steps that I've taken, this notion of just sitting back and listening, asking questions, being correctable, clarifying what I heard, taking correction, taking additional color, saying it all back again, and then we're all on the same page. And so over time, I have found that very helpful to get above the fray in the technical details, because you can chase that technical rabbit down a hole, but that's not the point, right? The point is getting the deal done. And so you need to elevate the complexity of the conversation and remove the complexity to understand the key features of getting the deal itself done.
So, Janine, in addition to technology transactions, you lead our student athlete and NIL practice team and advise athletes and institutions as they navigate college sport in the NIL era. You've also been pretty vocal about how the NIL system's evolving.
Yes.
First, for people not familiar, what is the NIL era?
So NIL stands for name, image, and likeness. And for people with an intellectual property bent, you will recall that you learned this as the rights of publicity. But now we've kind of plain English to name, image, and likeness. And so this era, which really started in 2021, in July 2021, provided athletes the opportunity for the first time to monetize their brand. And along that same time as the monetization of the brand took place, we saw the transfer portal open up so that athletes had more freedom in their ability to transfer. And so those two things, this ability to make money and this free ability to transfer, really are the two key features of the NIL era.
I know I can't believe it's only been 5 years, but
yeah.
Over that period of time, what's the biggest shift that you've seen or that you're seeing now?
Well, I think the biggest shift is that the NCAA in some ways has lost control, especially with respect to Division I football and basketball. But the other thing that has happened that has been a huge shift is, the NCAA has been under huge antitrust pressure. And that's one of the reasons as they've been trying to protect amateurism. And one of the outcomes of that has been this commercialization of name, image, and likeness. But also as part of a settlement, institutions can now directly pay athletes this year up to $20.5 million. All athletes across all sports. Most of that money is going into football and basketball, as you might imagine, is the top two revenue generating sports. And so as that's happened, as rev share has come online, as athletes have been able to commercialize their name, image, and likeness, as the transfer portal has allowed unlimited transfers since 2024, as we've seen about $2.5 billion being poured into college athletics this year alone. And so that's created anarchy, essentially, okay? People like to call it the Wild Wild West. I think anarchy is a much more precise term to describe what's happening, because there are fights on the eligibility front. Athletes now want more eligibility, want to stay in school longer so they can make more money at the front end of their career. Many of these athletes will never have professional careers. There are real issues about how to fund all of this and how institutions stay solvent in this situation. Managing the transfer portal when athletes are moving every year. So how do institutions keep teams intact? The coaching carousel. Coaches are continuously moving now in ways that does not show loyalty to the institution or to the athlete. And there's a fair amount of blatant disregard for the rules. So even though the member institutions are the NCAA, it is not unusual for them to simply ignore the rules of the NCAA. So all those things together have represented a huge shift in how we understand what's happening in college sports right now.
So maybe building on that, I know you've recently talked about the FTC's somewhat unusual scrutiny, perhaps, of NIL contracts, including concerns around agent conduct and Sparta. In really practical terms, why does that matter, and what should schools and student athletes be paying attention to?
Yeah. So, Sparta is this rule that the FTC has never brought an enforcement action against. And the rule is 22 years old. So I think the law came into effect in 2004. And so the FTC has never tried to enforce. Okay. Part of the concern is around agents. And so the only rule that there is to be an NIL agent is that you be a living human being. So anybody that is a living human being can be an NIL agent and represent a student athlete to negotiate their NIL contracts, their transfer portal deals, etc.
So you can't have AI agents.
You can't have AI agents yet. Okay. So they do have to be living human beings, but that is the only criteria. And so that's led to plenty of unscrupulous agent behavior. Okay. Agents teasing athletes to hop into the portal because the agent stands to benefit if the athlete does that and transfers successfully. It represents paydays for athletes, but not necessarily for paydays for agents, but not necessarily great paydays for athletes. It leads to poorly structured deals. So just think about the whole conversation we just had about contracts and how you think about technology and how you think about working through and structuring a deal with someone that is your cousin who lives 3 blocks away, who's never laid an eye on a contract, is now coming into the ecosystem, is going to try to negotiate a deal for you. So those are poorly structured deals. And part of the problem with all this is that if an athlete enters the transfer portal and does not emerge at a different school out of the transfer portal, they do what I call go home and sit on mama's couch. Because they have given up, for the most part, their scholarship. Their scholarship has been consumed by another transfer athlete, and they literally are done. And so this is a bad result. And so the FTC is trying to understand if it can get underneath this problem and understand the agent problem by asking the institutions, the universities and colleges to provide information on these agent relationships. Now, part of the problem might be that good agents haven't been following the rule because no one has ever enforced Sparta. So we'll see if good agents get caught up in this or if it really does serve as a proxy to catch unscrupulous or unsophisticated agents. So given that 30 to 40% of football athletes do not emerge from the transfer portal and do get stuck sitting on mama's couch, they should be really concerned that the agent that they are dealing with is high quality and that they have good options before they begin to pursue the transfer portal. And so that's why it matters for the student athlete. For the school, it matters because now the FTC is asking them under penalty of perjury and sworn statements and everything to certify what they have gotten and provide information about what they have gotten from athletes and agents to determine whether the athlete, the agent, and the school has complied with Sparta. So right now, the FTC is only asking 20 schools who have been unnamed, but my sense is, depending on the findings, they may go deeper into the hole.
So before we switch gears, I know we're just scratching the surface on all of these issues, but what's the best place for people to follow your work and your thinking on these issues?
Yeah. So Facebook, Instagram, TikTok. It's JBowRench Sports. So JBowRench Sports on all three of those platforms. And on LinkedIn, I am Janine Anthony Bowen. And I'm having fun talking about it. So I encourage people to come and have a listen and let me know what they think.
Now I'm going to go follow Janine on Instagram. I follow you already on LinkedIn. So
the spicy stuff is on Instagram.
And this is probably something that's also on your Instagram. So we know that you like to take vacations that, well, some people might categorize them as endurance events. And one of those that you did recently was climbing Mount Kilimanjaro. Mm-hmm. And you've noted that that was a way to remind yourself that you can still do hard things. What made you choose that mountain?
Well, interestingly, I was minding my own business back in 2019 when I got what I describe as a spiritual download telling me to go hike Mount Kilimanjaro. It had never occurred to me to climb any mountain that tall. Kilimanjaro was not in my consciousness. I had not been dreaming about engaging in any endeavor like this. It was not on my bucket list. But the message was so strong that I was clear that it was a spiritual message. So I booked a trip for July 2020, and I started training. And we know what happened. COVID stopped everything. So it took me 5 years to come back around to it, to respond to the call, to do the work to get to the top of that mountain was something that was very important to me. And the reason I chose that one is because that was the one that was placed in my spirit in a very deep and meaningful way.
So what did it feel like when you got to the top?
Okay, so first it was pure relief. Okay, because we were told that it was going to take us anywhere from 6 to 8 hours to summit the mountain. And so we started at 11 o'clock p.m. the night before, and we climbed all night long. This is just the summit attempt. We'd already spent 6 days getting to the summit attempt. And so we were told it would take us 6 to 8 hours, and it took my group 11 and a half hours. So we started at 11 p.m. and we didn't get there till 10:35 a.m. the next morning. So first was pure relief. And the second was just elation and sheer joy at having achieved the summit, because it had just been part of who I was for so long. To have done it was just a moment of sheer joy. And then came the release, because it was the culmination of 5 or 6 years of waiting and 6 months of grueling preparation and training. And then finally, it was just happiness and celebration. And so one of the great things about not getting there until 10:35 in the morning, which is really very late, is that there was no one at the summit but us. And so we had the whole summit to ourselves for about 20 and 25 minutes. There was no one in line trying to take a picture. We were all there. We were there by ourselves. And so that, having the summit to yourself after having worked so hard to get there, both in that moment over, the prior 12 hours, and then, the prior 6 months and the prior 5-6 years, it was, the satisfaction cannot be described. It's the hardest thing I've done and the most satisfying thing I've ever done.
So I'm almost afraid to ask, but what's next?
So nothing is on my mountain list. I don't have another mountain that's in my head that I want to summit. But I have been to 6 of the 7 wonders of the world. And so this year I'm going to cross off the 7th wonder of the world. And so the only wonder of the world that I have not been to is Petra in Jordan. And so I'm going to cross that one off this year. And so that's what's next for me in 2026.
That's very exciting. That one is definitely on my bucket list at some point. I don't know if I've done any of the wonders of the world, actually.
It's very cool. You should do them. I mean, they are all so amazing in different ways that once you begin to realize just the ability for mankind to do such amazing feats of engineering, it just boggles your mind. seeing Christ the Redeemer at the top of that mountain, like, how did they get it up there? I mean, it's just seeing the Great Wall. I mean, you just cannot imagine what it's like to look at those things with your own eyes, and it really changes your perspective on the world. So I encourage you to go knock the Colosseum off your list. That one's easy because that one's in Rome.
Okay, actually, I have seen the Colosseum. That one, I have seen one. I've got one on the list. I always tell people that Janine has the best travel guidance, by the way. So if anybody listening to this needs travel guidance too, great thing to reach out to Janine on.
Absolutely.
So as we wrap up, what's something you would tell every in-house counsel to pay attention to right now?
So that's interesting because I was looking for an in-house counsel specific answer, but I'm not sure if I have one that's specific to in-house counsel. But here's what I would say. In a world where folks are actively looking to replace humans with artificial general intelligence, not just in the workplace, but generally, we have to all be thoughtful about how we consider the value that we deliver and what we can do to future-proof our skill set. In-house counsel has the same set of issues that we all do in figuring out how we stay valuable in a world where things that are artificial at times are more valued than things that are real. And so I think their longevity and our longevity is tied to thinking about that deeply and beginning the process of repositioning ourselves so that we remain important and relevant in a rapidly changing era.
Thank you so much for joining us today, Janine. I'm very excited to hear more about the NIL stuff and to see where all of that is going. It seems like such an interesting space right now.
It's a lot of fun.
If you have any questions for David or Nichole, their contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of participants appearing in the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.